Hello and good morning, everybody. Just getting a few more things set up here. So Lori is back in court today. I believe Chad will be making an appearance also. They have a pretrial hearing and a couple of other motions are expected to be heard this morning. Good morning, Nana, Beach Bum, Lady D, good morning. So I've come across, you guys, some information regarding the new evidence that has been found that the defense for Chad has been fighting about, saying that they need more time because of this information. I don't know how much time we've got to go over that before this starts. It's supposed to be starting in about 5 minutes, but let me pull it up here and we'll see how much of it we can get through. Okay. Okay, there was an order to seal information, but I think I've got enough in this. Yeah, here it is here. We're going to go over this as much as we can, you guys. I'm going to be also watching for court to start. So as soon as court starts, we will jump into that. Good morning, Beach Bum, Lady D, Lynn, Sarah, Comptu. Good morning, good morning, good morning. Good to see you guys all here. So what I'll do is I will read through some of this and also keep my eye on the other screen here to see when this starts, and we will jump right to the court when it starts. Okay, hang on a sec. Let me share this so you guys can see it. I'll make it big so you guys can see it here. Okay. So what we've got here, I'm not going to read through it all, you guys. I will scroll. So if you do want to read through it all at another time, then you can do so. So this was filed on the 16th. And what this is going to show us, you guys, there was, let me just get into studio here so I can see what you guys are saying. Hang on a sec. Let me just put this over here. And then let me, whoops. Okay. Can you guys see it? Put one in the chat if you guys can see this document. It's not showing up on my studio for some reason. I'm really far behind in my studio. Okay, you guys can all see it? Okay, my studio is really far behind because it's not showing up in my studio. Okay, so the state's objection and brief in support of the objection to defendant's motion to dismiss the indictment or to preclude the imposition of the death penalty. Okay, so like I said, I'm going to just scroll through this. There's parts that I've highlighted that I want to talk about. And we're going to be doing this in between what's going on here in court. I keep bumping over here just to make sure nothing has started yet in court. Chad Daybell's lawyer is going to be arguing to sever, and then there is a pretrial. So that is what is happening today. So the pretrial hearing, but first there's going to be a motion. Chad is asking for the trials to be severed. Okay, so I'm just going to go through this quickly, you guys, because it looks like it's about to start. If you guys remember, there was some new evidence, some hairs that were found when they were doing some DNA testing. They wanted to do some DNA testing on that. So I'm going to scroll to that. And maybe we will go through the whole thing at the end. Okay, so on July 18th, the state filed a motion and brief regarding consumptive DNA testing of samples of materials located on J.J. Vallow's body. Okay, so the reason why they put off doing this testing, they had to wait until Lori was competent again so she could respond to their motion to do the testing, because it was going to be consumptive, which means they were going to consume the whole sample. They couldn't go forward with this until she was competent, so she could either agree or disagree with this. So that's why it took so long. So they had some evidence that was going to be consumptive. They waited until she was competent and arraigned, and then they said, okay, we're going to do this testing, but we're going to consume the whole sample. And each side had to argue whether they were for or against it or whatever, okay? So due to the small amount of the samples and the likelihood of consumption in testing such evidence, these samples were set aside since the co-defendant's case was stayed. This was done to allow both defendants the opportunity to analyze and establish a position with regard to the request for consumptive testing. Once the defendants agreed, the parties entered into a stipulation regarding the testing of such evidence, and the court assigned an order to that effect on August 15th. In late December, the state lab personnel notified the prosecution team that during the stipulated testing process, and it was on the duct tape, additional hairs were removed from the testing sample, which might have potential evidentiary value. However, the state lab had limited ability to test this evidence and was unable to retrieve any usable DNA. The defense counsel was immediately contacted, and the base of the timeline of the additional hair collection, the state located and secured a lab which could test such items on an expedited basis. On January 25th, the parties entered into a new stipulation regarding the consumptive testing of such items by the private lab. Okay, so as soon as they went to analyze this duct tape, they found some more hairs there that weren't found before, and everything had to stop. They had to get another hearing to see if the defense was going to be in agreement with sending those hairs that were found on the duct tape off to a different lab. So these are different hairs, you guys. These aren't the original hairs that were found. These are new hairs. So that's what they're fighting over. And like I said, we will go through this because it looks like court is starting. We will go through this at the end of this hearing if we have time. If not, I will do a full video on it. Okay? Let me just get my... Please smash that like button, you guys, on your way in. It's free. And it's very much appreciated. It helps get the channel out there in the algorithm and get the video out there so everybody can see what's going on and hear what's happening in court today. And it shows your support for the channel. And it's free. Takes 2 seconds. And when you come back in after hitting that like, make sure you have live chat selected at the top of your screen so you don't miss any of the chat. Okay, so Lori just walked into the courtroom. She has a blue blouse, black dress pants, full hair and makeup done again. She has shackles on her feet, and she's smiling as she walks in. Kay and Larry Woodcock, J.J. Vallow's grandparents, are in the courtroom about 5 feet behind Lori. They have erected like a little gate fence sort of like thing behind Lori and Chad so nobody can get to them. Like I said, you guys, this is also a pre-trial this morning, so we're going to hear a lot. It's going to be interesting, to say the least. Okay, so Chad Daybell has just entered the courtroom wearing a white dress shirt, a tie, and ankle shackles. He briefly looked at Lori. Oh, crap. Just give me a second, you guys. Sorry about that, you guys. Thank you, Lynn. Good morning, Crime Curious. I did send you a email, but you never got back to me, so. Okay, so Ada County, this is odd. Ada County Administrative Judge Stephen Hippler is listening into the hearing today as Daybell trial will be held in his county. So there's another judge listening in today. So Chad Daybell is in the courtroom. He's briefly looking over at Lori, who is chatting with her attorney. Let me just turn my heater here a bit because it's right on me. And what is happening here? Oh boy. Something's going on here. Stop. There we go. Somebody else was trying to join in. I don't know who that was, but that's okay, Crime Curious. We're all busy, so. Okay, so where was I? Okay, Ada County Administrative Judge Stephen Hippler is listening into the hearing today. Fremont County Prosecuting Attorney Lindsay Blake says state will be ready to proceed with trial on April 3rd. Court is finalizing a questionnaire that will be given to potential jurors. And for those of you who haven't heard already, Judge Boyce did deny the motion that was heard last week or the week before from Lori Vallow and her defense team asking that the case be dismissed due to lack of a speedy trial. He says the timing is okay given the complexity of the case and the seriousness of all the charges. So that was dismissed. So what is on the docket today, you guys, for those of you just joining? Boyce says is on the table today, pretrial conference, state motion regarding mental health evidence, and 3 motions from Chad's attorneys. There's a motion to sever the cases, a motion to dismiss the indictment, and a motion to compel. The state and Lori's attorneys both say they will be ready for trial April 3rd. Pryor says he will not be prepared by then. So again, Chad is saying that he will not be ready in time. Good morning, Fly Girl. John Pryor says we're not going to be prepared for the trial on April 3rd. John Pryor, Chad's attorney, tells Judge Boyce. Jim Archibald, Lori's attorney, says we're ready to proceed, Your Honor. Ada County is also ready for the trial. According to Judge Boyce, courtroom has been selected and is set up and ready to go. I'm doing good, Fly Girl. How are you? Good morning, Smiling is Contagious. So again, John Pryor is trying to, either way, he is going to try and get this trial separated. Both Lori's attorneys, Lori's side, the prosecution, Ada County, everything is ready to go. The only one who's not ready to go is John Pryor. Jim Archibald, who is Lori's attorney, says our witness and exhibit list will be fine-tuned and will be filed with the court 14 days before trial. So here's Jim Archibald, who's had a lot less time because don't forget, Lori was in the mental hospital and they weren't able to converse with her and all of this. They haven't had nearly as much time, maybe half the time that John Pryor has had to prepare for this case. And he's having everything to the court within 14 days of trial, and they're ready to go. Whereas John Pryor, who has had constant contact with Chad Daybell, because Chad Daybell's case was never stayed, he's had all this time to work with his client, and he's saying he can't be ready. And yet he's the one that asked and forced the January 9th court date, saying they're ready to go and let's go and whatever. And originally the prosecution wanted to only have the trial late 2023. And John Pryor said, nope, January 9th, we're ready to go, blah, blah, blah. And now here we are. Now he's saying that they vacated that date. And now he's saying he can't even be ready for April. Like, this guy is all over the place. You're very welcome, Lynn. Hello, Angela, Kimmy. Hello, everybody coming in. If you hear me clicking around, you guys, it's because I'm jumping back and forth between a few different people that are in the courtroom, so I can get you, like, one may put out something that the other one isn't. So I want to make sure you guys get all the information that you can. See, so let me just see this. Okay, so the judge said in a closed hearing yesterday, they took info on witness lists and information for the jury questionnaire. Those will be finalized this week. The state is arguing a motion to limit mental health evidence. They don't want mental health issues to be used as a defense for either Chad or Lori. Thank you, Fly Girl. Thank you so much. Yes, please smash that like on your way in, you guys. It is free. Okay, so the state is now arguing a motion that mental health should not be able to be used as a defense in the trial. Chad Daybell's attorney says he does not intend to use mental health as a defense. Judge grants the motion in Chad's case. So the state was asking that mental health should not be able to be used as a defense in the trial. The judge has granted that motion regarding Chad so far. Let's see what he's going to rule on Lori. John Pryor says they don't intend to use that in Chad's case. The judge grants the motion. Chad's mental health at time of crimes cannot be used as defense during the guilt phase. So we're still waiting for the judge to make a ruling on this for Lori. I wish that we could just stream this, you guys, because it's so much easier. But I know there's a big court case going on right now. Thank you again, Lynn. They're fighting for cameras to be in for this trial. So we already know that Letitia's is going to be, we're going to be able to stream Letitia Stout's trial. That is coming up. Her trial is set to begin. Let me just get my calendar here. March 20th, next month, like 3 weeks. Lori Vallow's trial start. Letitia Stout's trial starts in 3 weeks, you guys. And I will be covering that every day. So if you want to follow along with that one, I will be covering it. So right now the state is arguing against mental health being used as a defense in Lori's case also. Lindsay Blake says the state absolutely intends to talk about issues regarding the defendant's beliefs. We are concerned the defense may use that to open the door to argue mental health as a defense. So the defense is saying they filed a motion saying that they don't intend to use mental health as a defense, but that there have been mental health competency issues in the past. Even if not used as a defense in trial, they want to make sure it's not used in the penalty phase either. Okay, so that's the state. They want to make sure that the defense can't use that in the penalty phase either. They're still reiterating that they're concerned the defense may use that to open the door to argue mental health as a defense, not only in the penalty phase but throughout the trial. They're concerned that that may be used. Sorry, you guys, my phone was blowing up. My sister is in court herself today, so Well, thank you, Lynn. Like I said, you guys, I know a lot of the news outlets are fighting this ban on no cameras in the courtroom. So hopefully they can get the cameras in for the trial, which is going to pose a problem for me because Letitia Stokes' case will be running at the same time as Lori Vallow and Chad Daybell's case, because Lori's is supposed to run, I think, 9 weeks starting March 20th. So that brings it maybe into the beginning of June even. And Lori and Chad's case starts April. So we're going to have an issue. Unless Lori takes this deal. Like, we do know that the prosecution has offered Lori some kind of deal. We don't know what that is, but we do know that they offered her some kind of deal. Okay, so Jim Archibald, Lori's attorney, objects to the motion. Our mental health experts still have questions about her competency. We do respect the court's opinion that she is competent for trial, even though there are differing opinions on this matter. So Archibald is saying in Lori's mental health assessments, experts say she does have mental illness, no question. But because she's never said, hey, I did it, but I was crazy, then the Idaho law saying mental health illness is not a defense does not apply. Oh, thank you, Lynn. Yeah, like I said, the Letitia Stowe case is going to be a lot easier because I can just stream it for you guys and you guys can watch it all as it's happening. I don't have to do this reiterating information that's coming out of the courtroom to you guys. But right now there's a ban on having cameras and that in the courtroom for the Lori Vallow Chad Daybell case. Hopefully the media wins their case against this and cameras are going to be allowed, hopefully. But if not, I will be doing exactly what I'm doing now in between the Lori Vallow case and the Letitia Stout case. Yeah, this is with her and her husband broke up. She's our mod here, Des. Darren D, don't know do yours. She's my head mod actually. And yeah, she's in court today, so I'm hoping everything goes her way. But thank you, Fly Girl. That's why she's not here in chat today, you guys. Archibald said she believes she won't be convicted, so mental health evidence shouldn't be an issue. This is what Archibald's saying. But if she is convicted, then they would present mental health evidence at that time for the jury to consider during the punishment phase. Archibald says they still have some questions of her competency, but they respect the court's decision that she is fit for trial. Archibald is saying all all the mental health experts that have dealt with Lori have evaluated her says she has a mental health issue. There's no question. And again, he's reiterating that Lori Daybell believes she will not be convicted. So we're getting these motions out of the way first, you guys. And then they will be going into the pretrial, which is going to be interesting. So yes, there's Crime Curious. We've been trying to get together for a while. She's very busy. She's hopping state to state over there with a lot of stuff she has going on. Jen's been on my panel before. A lot of good information comes out from Jen, Crime Curious. Crime Curious, you guys, is also writing a book, and she is going to be in the courtroom for Letitia's trial. So if you haven't subscribed to her, head on over to her channel and give her a like and a subscribe. And she's got a book that is going to be coming out. So currently in Virginia. Okay, let's see what we got going on over here, you guys. Okay, Archibald says our witnesses will be very few during the guilt phase of the trial. The trial has two phases, the guilt phase and then the penalty phase, if the defendants are found guilty. Archibald is saying that they still have some questions of her competency, but we do not intend to open the door. We do not intend to make mental illness an issue during the guilt phase. So during the trial, they don't plan on using mental health as an issue for the reason why this happened with what they're charged with. But they may use that in the penalty phase if they're found guilty. They may use her mental health issues for that in that phase. Judge Boyce is to issue a written ruling, so he's taking it under advisement on the mental health motion concerning Lori's case. Lynn Carson, just a second, and I'll put her channel up here. I'll put a link to her channel. Oops. Just gotta go over here and grab the link, you guys. Just give me a second. So there's the link to Crime Curious's channel, you guys. If you want to go and check it out, like I said, she's in the process. Of this book being written. It's going to have a bunch of the cases that we cover. She is going to be in the book. So please go on over there, subscribe, give her a like, and watch for that book. Thank you, Lynn. I'm sure Crime Curious Jen will appreciate that. Thank you. There's Marie. Hello, Marie. You're very welcome, Crime Curious. Okay. So let's see what's going on here now. So the judge has ordered that they cannot use any mental health in Chad's case. Lori's case, he's going to take it under advisement and issue an order regarding hers. So now they're going to get to, before the pretrial starts, you guys, they have a couple of motions. So Boyce grants a motion in part. Neither state nor defense will be allowed to use any evidence or witnesses related to mental health during trial. As to the rest of it, whether it's allowed during the guilt phase, he will take it under advisement and issue a ruling later. So they can't use any mental health for Chad or Lori during the actual trial. Under advisement, he's taking into consideration if mental health can be used as some kind of, lowering of the punishment if they're found guilty. So now they're on to the motions filed by John Pryor, Chad's attorney. First is the motion to dismiss the indictment. The judge is going to be listening to that motion first. And then we will jump into the pretrial. So Pryor's now arguing his motion about the DNA evidence. The trial is going to start in 21 business days to date, unless I'm mistaken. There is DNA evidence that is still outstanding that I don't have in my possession. I showed you guys that. Let me bring it back up for you again. Show you what he is talking about. He is talking about this right here. In late December, the state lab, I explained this earlier, because Lori was not competent. She was sent for evaluation again. They had to wait until she was competent for the judge to make a ruling if the prosecution could consume, because the sample was so small. It was a piece of duct tape, I believe, and the sample was so small that it would be totally consumed. So until she was competent and her lawyers could argue whether they're for or against the prosecution consuming this evidence, they had to wait. So the order wasn't made until August 15th of 2022 for this evidence to be, that they could use this evidence and consume it. So in late December 2022, the state lab personnel notified the prosecution. Hang on a sec. Sorry. I notified the prosecution team that during the stipulated testing process, additional hairs were removed from the testing sample, which might have potential evidentiary value. However, the state lab had limited ability to test this evidence and was unable to retrieve any usable DNA evidence. Defense counsel was immediately contacted, and based on the timeline of the additional hair collection. So this is new hair that was found, guys. It's not the old hair. Well, I don't want to say old hair, but it isn't nothing to do with the hairs that were already found previously. These were new. So when they went to test this sample in December, they found more hairs and they wanted those hairs tested. So the state located and secured a private lab which could test such items on an expedited basis. On January 25th, The parties entered into a new stipulation regarding the consumptive testing as of such items by the private lab. And with that, the prosecution also agreed to allow the defense more time to reply to that evidence. So they're doing everything to keep, to give the defense extra time to go through the reports on that evidence or DNA, if any was found. We don't know because it's all under seal. So what we do learn from that is on one of the pieces of duct tape, they were going to consume the whole sample. So they had to wait for Lori to be competent again so they could argue or agree to the prosecution consuming this piece of evidence. They agreed to let them do it. And in December, when that was sent over to the lab found more hair in the duct tape that they didn't find previously. So that's the new hairs that were found. And the prosecution doesn't know if it's going to be inculpatory or exculpatory. It could go for the defense. It could go in favor of the prosecution or defense. If they find a hair on that duct tape that isn't Lori, Chad, Alex, or JJ, that could open the door to somebody else. So even not knowing if the prosecution is even going to benefit by that, they did send it away. They let the defense know that this is what we're doing, and it could be exculpatory. So it could help the defense, or it could not. Or it could place one of them, Lori, Chad, Alex, at that scene. Okay? So that's where they're at with that. That's why John Pryor is now saying that he just got all this new information and blah, blah, blah. There's also other things, like I said, in that document that I just showed, that he says he wanted notes on every single tip that came in. So generally they don't have to hand that over. If there's something that they investigated through one of those tips that may have led to something exculpatory or inculpable, then they would have to disclose that. But if there's other stuff that's there that they didn't even think was an issue or whatever, you'll see that in the documents. Some of it does mention the psychic readings and stuff. They didn't feel that they had to turn that over to the defense because they never questioned me about any of my readings. So because I was never questioned, I wouldn't be, that wouldn't be disclosed, or they didn't feel they would need to disclose that. I don't know. But anyway, let's get back to this. So that's what they're arguing about, this DNA evidence. Oh boy. John Pryor is not happy. So what they were arguing about before I showed you the document was the DNA evidence. And he says, unless I'm mistaken, there's DNA evidence that is still outstanding. Doesn't have it in his possession. Pryor says, it's not my problem. It's not my problem about the DNA evidence and what's going on. This is all on the state. They have an obligation to receive and process DNA evidence. I think he's being a little ugly there because the state couldn't consume that DNA evidence until they had a hearing. And the judge ordered them allowed to consume that DNA evidence, or that evidence that would be totally consumed, without having any given to the defense. He couldn't make that decision until Lori was brought back from competency to competency. So, I mean, I think he's being a little cranky here. He says, you're going to hurry me? You're going to rush me for having to evaluate this in 21 business days because the state can't get their act together? Well, this isn't on the state. Like I just explained, they had to have a hearing to be able to consume this evidence. Lori's attorneys couldn't give the okay to consume it because she was incompetent. Her case was stayed, so they had to wait for her to be back in court to be able to give her okay to do this. They're trying to put it on the defense, and it's on the prosecution. It's not the prosecution right now. It's the defense that held this up. They can't give me sufficient amount of time to do what I need to do in this case to evaluate this case. And what I'm going to say with this is Lori Vallow's lawyers have had a quarter of the time to get this case together than what he's had. He's had over 2 years. Don't forget, Lori was sent away for evaluations where her case was stayed. So they've had very little time to get their case together, and they've been able to do it. So John Pryor, I don't know what you're trying to get at here. The prosecution and Lori's team has the same amount of time as you are going to have when the results of this DNA evidence comes in, and they feel that they can go forward and they will be prepared for it, but you're the only one that's not going to be. So it's getting, he's trying to get these cases severed, and this is his last ditch attempt. Pryor says he received evidence on Monday, President's Day. He had to meet the FedEx delivery driver at his office and then overnight the evidence to his expert. He argues this is not giving him enough time to prepare for trial. Well, if the prosecution can prepare and the other defense team can prepare, I don't know why he can't. They're each going to have the same amount of time with this to go over this evidence that everybody else is. Pryor says evidence in the case includes hair samples from each of the defendants, Chad and Lori. In the month of February, just in the month of February, there have been 4 supplemental evidence given to me, including tips that were involved in this case from 2019. That's what I was just speaking to you guys about. It's in those documents that they want every single tip that came in. So say I called in a tip to the police station and said, like, we know that Lori is already incarcerated, Chad's out, but I call in a tip saying, hey, Lori and Chad were just skiing with me today. We know it's not true because Lori's incarcerated and Chad is in Fremont. So how could Chad and Lori be skiing with me up here in Canada, right? So it's, and they do, believe it or not, you guys, I believe that the police get a lot of tips like that, okay? I seen them both skiing today. They're just going to disregard that. But the defense is saying you had to give us that tip, even though it's impossible that it could be true. You didn't give it to us, and we should have had it. So what the prosecution did is every single tip that ever came in, whether fraudulent or not, they gave to him. And now he's complaining about getting it. Oh, now we got all these tips that we got to go through that came back in 2019. But this is what you asked for. So don't ask for something and then complain about not having enough time to go through it all. When this, if it was, by law had to be turned over to the defense, then it would have been. But you asked for all this garbage that also came in, so you got it. So don't use that now as a reason to prolong this trial or not being able to be ready. That's on you, Pryor. Be careful what you ask for is what I always say in cases like this. And like I said, Lori's team has had a lot less time, a quarter of the time, to get ready, and they're ready to go. Pryor says, if they inadvertently missed something and didn't provide it in a timely fashion, that's fine. But that doesn't mean I should have to rush and prepare for trial at the last minute because the state can't get their act together. Wow. Wow. Like, he's pulling out all stops here, you guys. And this is, I don't think even Pryor believes this himself. But this is his last ditch attempt to get these trials severed. So he says DNA expert will need about 8 weeks to analyze the DNA evidence and be prepped for trial. This is all on the state. This is not a defense issue, which is bullcrap. This isn't a grand theft case. This isn't a DUI case. This is a capital case in which the state is trying to impose the death penalty on my client. This is the most serious kind of case you can be involved in. Pryor is calling the state's process on this sloppy. It's not. The state could not do any testing on this evidence until Lori was brought back to competency and could okay the state to consume the evidence to do this testing. It's not the state's problem. It's not, it's because she was incompetent. They couldn't hold a hearing on it until she was brought back to competency and arraigned. He says, this is the most serious kind of case you can be involved in. Calls the state's process on this sloppy. Pryor says it's blatantly unfair for them to rush him to evaluate this in 21 days because the state can't get their act together and give him the evidence he needs in a timely manner. As soon as they got it, they gave it. Oh my God. He says some of this evidence is recent, but some prior claims state has had since 2019. They're just now getting it because you said you wanted every single tip, no matter how far-fetched it is. A tip could come in saying that they were having dinner with the Queen of England. They wanted that tip. You asked for it. You got it. Anything that the prosecution felt could be exculpatory or inculpable, they gave to the defense. But the defense wasn't happy with that, John Pryor. He wanted everything, even if there was a tip that, like I just said, that came in to say, we just had dinner with the Queen and Chad and Lori. They wanted that tip. Well, then they had to go back all through all them tips and give them every single tip that came in, no matter how far-fetched it was. So that's why they had to go back to 2019 and get up a spreadsheet of every single tip. Okay, and it amounted to, with everything, because what the prosecution did is they printed out every single tip, every action that they took on those tips and everything, even if they were, like I said, we just had dinner last night with Chad and Lori with the Queen of England, rest her soul, when she was alive. You know what I mean? Every single stupid ass tip that came in was included, as well as all the other tips that could be exculpatory or inculpable. Every single tip that they ever got, they got together, put it all out there, printed it all out, and he ended up with 1,188 pages. There you go. That's what you asked for, John Pryor. So that's what you got. And now you're complaining that now that you've got all the tips, it's so much to go through. Be careful what you ask for. That's not on the prosecution. That's on you. They have to, by law, turn over anything that could be exculpatory. They did that, and it wasn't good enough for you. You wanted even the crazy ass tips that came in. Well, you got them. Oops. Oh my God, this. And like I said, you guys, I should expect this, and I do, because he is fighting to have this case severed, and he's going to use, and I think he did that on purpose, knowing that they've got everything that could be exculpatory or anything else. They know they've got it. But this was a stall tactic. Okay, well, now I got 1,188 pages to go through that I just got in the month of February alone. Well, those are things that you asked for. There was also things in there, you guys, included that they had already gotten back in 2019, 2020, 2021, that they said, oh, well, we can't find it. Well, just because you can't find it, John Pryor, does not mean that you don't have it. So you can't blame the prosecution for you not going through every single thing and finding what you need. It's not up to the prosecution to go out and hunt down all of this for you and point it out to you. If they've given it to you, it's up to you and your team and your secretaries and paralegals and everything to go through every single document and find what you need. It's not up to the prosecution to baby you and say, okay, that's there, that's there, that's there, that's there, and here's this, and here's. It's not up to them to point it all out. It's up to them to get it all to you, and they did. Oh, it just irritates me. Irritates me to no end. I mean, to try and get this stalled and everything else is one thing, but to blatantly try and throw the prosecution under the bus and say they're doing something they're not, I don't agree with that. Okay, so Pryor is also discussing evidence from 32 electronic devices. It says there are 12 terabytes of evidence which would fit in the back of a cargo van. Also references 26 journals the state has, claims they have piecemealed the evidence into discovery. The state can review this anytime at their leisure. Pryor cannot. He says they have been sitting in this evidence since 2019. Well, they sent it to you. They sent it over in 12 terabytes. You have 12 terabytes of evidence. It's not up to the prosecution to baby step you and walk you through the evidence. They sent it to you. You have it. Don't say you don't, just because you don't want to go looking for it in the 12 terabytes. Finding stuff on computer is a lot easier because you can punch in certain phrases or words or whatever, and it will find it in those documents. So if you're concerned about blood evidence, you can type in blood evidence and it will find it within all those documents. Yep. And he says the state can review this at any time at their leisure. So can you, John Pryor. It's on that 12 terabyte of evidence you have. So stop it. It's crazy. Pryor saying the 32 electronic devices and 26 journals were seized from Chad Daybell's house. This will be evidence in the case. Pryor says there's 12 terabytes of data that has been submitted as evidence. That's enough to fill a cargo van. Pryor says even if state gave him all outstanding evidence by next week, I'm not going to be able to get through it all. There's no way. Even with the additional support staff I have, there is no way I'm going to be able to get through all the evidence. Well, he's trying to make it sound like this 12 terabytes of data has just been submitted now. That's been submitted over the last 3 years. In the last 3 years, since 2019, 2021, 22, that's probably 12 terabytes in the last 3 and a bit years that's been given to you. He's trying to make it seem like it was just slapped on his desk today. And it's the judge is going to see through that. There are 12 terabytes, enough to fill a cargo van. Yeah, but that's over the last 3 years. And that's if you had it in paper form. You don't. You have it on computer. You have it on drives and all this, external drives and stuff, where you can type in certain things that you're looking for and boom, it'll pop up. Pryor says, even if the state gave him all outstanding evidence by next week, I'm not going to be able to get through it all. There's no way. As Pryor presents his argument, Lori Daybell is focused on taking notes. Chad Daybell looks straight ahead or down at the table. They're providing Pryor is saying they provide little bits and pieces of evidence and saying, catch me if you can. So it's like, okay, if they're providing, you just admitted they're providing you bits and pieces at a time. Look at it when you get it instead of letting it pile up, and you should be up to date. Provide it to me if you can. How do I know? 500,000 GPS points that were never provided to me originally. 1,188 tips that were not given to me until the last month because you just asked for even the ones that didn't matter. Pryor says either they're trying to sandbag me or there's a lot of incompetence and nobody's watching or directing the ship. The judge says, he says to the judge, for you to punish me and have me go through all this evidence at the last minute because they can't get their act together, it's not my fault. Pryor saying Lori's team does not have all the evidence either and says Ms. Vallow, then stops saying Vallow and says, Vallow Daybell, excuse me, ma'am. Lori nods her head. Huh. So he corrects himself because he was just going to call her Lori Vallow and corrected himself. They haven't even got to the pre-trial yet, you guys. They're still fighting about this stuff. Hello, everybody coming in. Pryor says, this delay is not on me in any way. This delay cannot be put on me in any way. This is a complete breakdown on the prosecutor's office. Judge, I'm asking you to dismiss this indictment. In the alternative, I'm asking the court to consider and reconsider the severance motion because I cannot be ready. I told you. This is why he's doing it. He wants this case severed. And he's using anything and everything, even if it's lies, to get it. Pryor is continuously refers to Lori as Ms. Vallow. Pryor said he should not have to go to them to get this evidence, claims he would need to sit in their office 10 days to get all the evidence. I don't know why Mr. Archibald is going forward with their case because Pryor thinks they don't have the evidence either. So he's saying that Lori's team doesn't have the evidence either. Hello, Jimmy, and welcome. He's saying I cannot be ready for trial. Says the delay, again, is not my fault. It's the state's issues. No, it's not. The judge is going to see through this, you guys. For these reasons, I'm asking the court to dismiss the indictment against Chad. If the indictment is not dismissed, I'm asking the judge to reconsider his motion to sever the cases. Wow. I bet you the judge takes it under advisement. So Fremont County Deputy Prosecuting Attorney Tanya Rawlings is going to be responding to John Pryor. Uh-oh. Now, this one is usually pretty good. Tanya Rawlings. We don't hear a lot from her, but with stuff like this, she is generally really good. at getting points across and breaking down what John Pryor just said and taking away all credibility of what he just said. She's good at this stuff. So let's see how the state is going. I believe the state is going to reply like, look, they have gotten this information over the last 3 years, the 12 terabytes that he's trying to make it look like he just got thrown on his lap today. They're going to, she should go into that, Your Honor, is over the last 3 years. And the pages that he is complaining about just getting were at his request and included a lot of tips that came in that were just totally off the wall. Like I gave it as an example, if I was to call in a tip and say, I'm sitting with Chad and Lori with the Queen of England and we're having dinner and tea. You know what I mean? They're here. That would be the kind of tip that they would say, person's off their rocker, dispose of it. You know what I mean? But John Pryor wanted all that. Well, you got it. Don't complain about getting it now. Okay, so let me see if anything else has come out yet, you guys. If not, I've got some notes that I'd taken here. Okay, Pryor also says that he recognizes that having collected these additional hairs at a later date is problematic, right? Because Lori case was stayed, so they couldn't reply to it, so they couldn't do nothing until they could have both defenses there to argue their points. Okay, so we recognize that having collected these additional hairs at a later date is problematic, so the state, out of concern for that, did make significant efforts to find a smaller lab to test the hair. Hello, Hockey Mama. Thank you. Well, I forgot to say thank you when I joined. Well, thank you for joining. Oh, you're very welcome, Lynn. I try my best. Okay, the prosecutors are saying the state lab results on additional hairs found no DNA profile. They are looking for a private lab to test smaller hairs that don't have the roots. Private lab in California found to test the smaller hairs. Their turnaround is taking a little longer than expected, but they're hopeful to get those results today. So the additional hairs that were found, there were some with roots and some with no roots. So they were looking for a private lab, which they found, to test the smaller pieces of hair that didn't have the roots. They did find one. This is back in, I believe, January. They did find a private lab in California to test the smaller hairs. And the turnaround was taking a little bit more than expected, but they are hoping to have those results today to see if there is DNA that can be extracted from those smaller hairs. And they're saying as soon as they get the results, the defense will have them right away. I don't know what they've already agreed to consumptive testing on this sample. So I don't know what he's talking about, his experts. His experts maybe want to speak with the lab or go to the lab themselves that did the testing on the smaller hairs to see exactly how they did it, or if it was videotaped how they were doing it. He wants to be able to go over that videotape. That shouldn't take more than a day or so. Like, stop it. Like, it's crazy. It's crazy. Turn off that heater, you guys. Making a lot of noise. So once they get the results, if there's DNA, I do believe that what is happening there is whoever did the testing on those small hairs in California, they would have had to video record the whole thing, how they were doing it from the time they open that sealed sample to the time the test is finished and results. They would have to videotape that whole thing. So that would probably take, whatever time, say a couple hours, whatever. It would have to be videotaped. It's not going to take that long for John Pryor to go over that videotape to see how they processed that sample, and if they got DNA out of it, how they extracted that DNA. It's not hard to go over a report. But like I said, he's exaggerating a lot of things to make his argument to have the cases severed. If you got the prosecution, the one defense team, which is Lori, you got Ada County, the courtroom, everything. Everybody's set up and ready to go on this, but John Pryor. There's an issue there. Especially when he's one of the lawyers that has had the most time with all the evidence in this case. You got to remember, it's just not John Pryor that doesn't have this evidence yet or the results. It's also Lori's team and the prosecution doesn't have it yet either. So you all are going to have the same amount of time to examine that. The state said the motion to dismiss the indictment is extreme remedy that is not justified. And I agree. Sorry, you guys. So Rawlings is saying the state lab could not test the small portions of hair for specific DNA. They were looking for specific. It's in the paperwork, you guys, that when they fought about it was under seal, but they had to, I don't know how it came out in there, but it did. It should have been reacted, but it wasn't. They're looking for the Y chromosome in these hair fibers that they found. So Rawlings says state lab could not test the small portions of hair for specific DNA, which is the Y chromosome they were looking for, evidence in a quick manner. So a private lab was found in California for testing. Pryor was notified of this, according to Rawlings. Rawlings says state experts report on the lab testing of their hair today. We don't have the results now. We don't know whether they were able to obtain anything. We just know that they have the ability to test the hair in a more extensive manner than the state lab. I fully emphasize with defense counsel as far as going through the vast amount of evidence in this case. I recognize there is a vast amount of evidence. The state has been going through discovery again since November to make sure everything has been turned over. So it's like, it's John Pryor, it's not just you that's had to go through this mountain of evidence in the last 3 and a bit years. It's the prosecution and the other defense team also. And they've been able to do it. The only one that can't do it is you. So are you saying you're incompetent? Because that's what you're saying right now. If all the other people and players in the game have been able to get through it and are ready to go for the April 3rd trial, and you are the only one that's not, hello? Who's the common denominator? You. Maybe you're the problem, John Pryor. My opinion only. But I also have to realize that he's playing dumb right now and playing stupid because these are his arguments for severing the trial. But I think he could have had a little bit more couth with how he was doing it, instead of throwing blame at people that he knows are not to blame. But this is his way of doing things. Rawlings is saying that the devices seized from Chad Daybell's home back in January of 2020 are not relevant to the state's case. As for the journals, they were disclosed in the previous Chad Daybell case before the indictment, so the defense has been aware of those for some time. And that's exactly what I was just saying, you guys, like 20 minutes ago. You've had this information since the beginning of 2020. Don't say that you were just handed it all now and group it all together with documents that you asked for right now, i.e. all the crazy tips that came in. You wanted those too. Don't group that together with what you just requested and then try to say that you just received all of this information when it's not true. You received that back in 2020. And that's what I mean. Like, he's pulling out all the stops, and this is the reason he's doing this, is because he wants this trial to be severed. He's thinking he can pull a fast one when he can't, because we're quicker than him. And I'm sure the judge is too. Obviously, the prosecution is. The state says they had no DNA evidence until bodies were found in June of 2020. So Pryor's reference to 2019 are incorrect. State also mentions some issues with corrupt files and files not copying over, which is the reason why he has gotten recent supplements. Each tip was contained on a separate sheet. So every stupid, crazy tip that came in was on its own sheet. So many of the 1,188 pages are largely blank, not as voluminous as it sounds. State learned of those earlier this month, which was why Pryor didn't get it until recently. So, apparently, why would these pages be blank? They could have been printing out stuff and getting, and I know it happens on my printer sometimes. I'll print out one page, and the next thing you know, I got 4 pages that are sitting there waiting for me to look at, and only one page has something on it. So you got 3 pages that have absolutely nothing on it. That could be it too. This is crazy. Three years, Jimmy. 3, 20, 21, and 22. We're in 2023. 3 years. He's just trying to get this severed. That's what he's trying to do. Rawlings says there is a voluminous amount of material in this case, and most of this material has been available for inspection and review for over 2 years. Over 2 years. Which is true. There's a lot of stuff, if it couldn't be put onto a drive or whatever, the prosecution sent information to the defense saying, look, we've got this. You can come here anytime, take it and inspect it. Anytime during business hours, come and inspect it. You can take pictures, photograph, whatever you need to do. You can do it. It's here. Come and check it out. Now, if he doesn't go and check it out, that's not on the defense. That's on him. So when they talk about having material there that's available for inspection, it's material that can't be released from evidence room, or is too large, or whatever the case may be. There's a reason why it can't be sent on a drive or something. So they have the ability to be able to go over there and inspect that evidence, take photographs, whatever they need to do with the evidence. Give me a second, you guys. I gotta blow my nose. Sorry about that. So the new hairs that they are talking about, you guys, was found in the duct tape that was sealing the plastic bags that JJ was found in. This is a new sample that they came across that was going to be consumptive, just to give an update for those coming in. They couldn't get a hearing on it to use it and consume that piece of evidence until Lori was brought back to competency. Once she was, they had a hearing. The judge ordered, because both defense agreed, that the prosecution could consume that piece of evidence and get it tested, as long as it was videotaped and they could go over how each step was done. That was done in January. There was also other pieces of hair that were found, new hairs that weren't seen before. Once you get them under a microscope, you could see a lot more. There was other hairs found there. Some had follicles on them, some didn't. The smaller ones, the state lab could not test, so they had to send that out to California to a state lab that specializes in testing for DNA where there's no hair follicle. That was done in January. They are awaiting any day now the results of that. The prosecution doesn't have the results, and neither defense has the results yet. So they're on equal footing there. When those results do come in, they're each going to have the same amount of time to go over that. John Pryor is the only one saying that that does not leave him enough time. So I think at this point, the problem is John Pryor, and I do believe that he's using this to get his case severed. Now, the reason, I'm just going through my notes here. The reason why, and trigger warning, trigger warning, trigger warning. The reason why the state lab could not do the testing on the smaller fibers is because they didn't have the technology with their equipment to be able to test those smaller hairs with no follicles, because they were embedded in the duct tape and soaked in bodily fluids. So it takes specialized equipment to be able to process those hairs that have no follicle. Okay, so there's a difference if it has a follicle or not. Okay. Okay, so what they are looking for, they're looking for the mitochondrial and potentially Y chromosome DNA on the small hair samples. Okay, so they are really concentrating, this is the prosecution, it's really concentrating on finding the mitochondrial and potentially Y chromosome DNA on these small hair samples. Okay. Now, that is going to show whose hair that is. Could it be Lori's? Could it be Chad's? Could it be Alex? Could it be JJ's? Because it's a short hair. Okay. So that's what they're looking for, is the Y chromosome DNA on the small hair samples in the mitochondrial DNA. That's what they're looking for. That's important, really. because the only way that that type of hair could be on that duct tape, on the piece of duct tape, you know, could be halfway down the roll. That means that person had to have been there. It's not just the duct tape end was open, like away from the roll itself, and anybody passing by could have deposited that. If it's further down the line in the duct tape that had been rolled up in the duct tape, then that hair has got to be one of theirs. Whoever wrapped him in those bags and used that duct tape. There was also fingerprints on that duct tape, you guys. Again, let me just see. Okay, so clarification on that is part of his motion is to dismiss the indictment. Prior is also asking to dismiss indictment or take the death penalty off the table. So Prior is up for rebuttal now. Whether the state just got these tips or not, there's still hundreds of pages for him to go through, with the trial slated to start in just a matter of weeks. Prior now hints at incompetence of law enforcement because they didn't get some evidence to prosecution in a timely manner. Now, he's talking about the tips again. We just talked about those tips, where these tips were not followed up on by prosecution or police or anything because they were right off the wall, were physically impossible. Could have been somebody saying that they just had lunch with Lori, but Lori's been locked up for the last year. How can you be having lunch with her today if she's locked up? So they would disregard those tips. Well, John Prior wanted all those included. So what they did is any crazy tips like that, they included those, as well as all the other tips that came in that they did maybe look into or go on. They just printed them all out again and sent him everything, including the crazy ass ones that were impossible. Okay. So that's on you, Prior. But Prior, and this is what I said earlier, and now we just got somebody that's in the courtroom reiterating what I just said like half an hour ago, that he's trying to say that the police are incompetent, the prosecutors are incompetent, everybody's incompetent. No, John Prior, it's looking at this point that you are incompetent. If this is the excuse you're going to use to prolong this trial and have this severed. I mean, he's going to use what he can use to try and get this case severed. But I think he's going a little too far when he starts insinuating that others are incompetent. That's going a little too far. A little too far. And you throw daggers, you're going to get daggers back. Prior says he shouldn't have to rely on the state lab test results and conclusion there was no viable DNA sample. He wants his own expert to be able to test it and form his own conclusions. Well, wait a minute, Prior. You've already agreed to consumptive testing. How is your expert going to test this sample that was consumed? It doesn't make any sense. And I don't know, that's not going to fly. And I think this is John Prior doing his rebuttal right now. And once the prosecutor gets back up, I think this is going to be talked about, because he already agreed to consumptive testing, which means the whole sample is going to be consumed. There's nothing there for you to retest. Like, you get one shot at it. That's what consumptive testing is. You get one shot. So what is it that you want to test? What is it you want your expert to test if it's already been consumed? To me, it doesn't make any sense. And I think the prosecution, when they get back up, will be saying something about that. The state had argued that they had turned over all evidence in a timely manner and have communicated with the defense attorneys when there's been delays. Even when they found this new evidence right away, they called up the defense. Hey, look at this is over there, that, you know, that thing you just agreed to for consumptive testing. They found something more on there. Just letting you guys know. And Lori is still writing in her notebook almost continuously since the hearing began 90 minutes ago. Yeah, I think the judge is going to say, no, you've had more than enough time, and I don't think he's going to sever them, and I think he's going to force John Pryor to go to trial on April 3rd. Now, don't forget, at one of the prior hearings, John Pryor had said that if they're forced to go to trial on April 3rd, that Chad Daybell was going to fire him. If they fire him, it's going to be severed anyway, or they're going to have to put it off again, and that's not fair to Lori because she hasn't waived her right to a speedy trial. So if they force this trial to go ahead, I can see what John Pryor said. His exact words were that Chad Daybell was ready to release him if they are forced to go to trial on April 3rd. If he releases John Pryor, that means he gets more time to get his new lawyer up to speed. Like, it's crazy, you guys. So, like, he's willing to pull out all the stops to get this trial severed. Sherry Krause, if you go to my YouTube page and click on the video tab at the top, if you click on live instead of videos, click on the live tab, everything with her is there under the live tab. Even if it was a reading that I uploaded, it still goes under the live tab. Everything from 8 months ago up to today is all under the live tab on my YouTube page. And as far as the Nicola Bully case, from what I'm hearing, is she was found partially on land by the reeds, in the reeds. Oh, thank you. Glad you're here, Sherry. Okay, let's see if there's anything else over here. We're still waiting for the pretrial part of this to start, you guys. Okay, so Boyce makes a point to tell Pryor that with electronic evidence, the prosecutor keeps possession of devices so things aren't just floating around out there. Okay, so that's what he means. Like, they could come in and inspect the phones or laptops or whatever, but they couldn't take it with them. They could copy anything, put stuff onto jump drives, whatever they needed to do, but they couldn't take the physical item with them. He tells Pryor he's welcome to go review the evidence at any time at the prosecutor's office. And he's been told that for the last 2 years. Anything that we can't put on a jump drive or whatever, or you want to inspect, it's here for you. Come on in and inspect it. John Pryor hasn't done it. But now don't claim foul that you didn't get to inspect those items if you didn't go there to inspect them when you know you could have. That's not on the prosecution, guys. No, I don't know. If he fires his lawyer, that lawyer's fired. You can't have a lawyer that the client's not willing to work with or doesn't trust. And that's what Pryor had made a spectacle saying, well, if I can't get this put off, my client doesn't trust me, he's going to fire me. So yes, he can be fired. Chad can fire him. And I do believe Chad is paying his own lawyer. So Chad can fire him. Even if he was appointed, if he doesn't have trust in his lawyer, yes, he can fire him. Even if the state's paying for your lawyer. If you can't get along with your lawyer, or you don't trust your lawyer, or you don't feel your lawyer is doing right by you, you can fire him. Perfect example, look at the Letitia Stout case. She had public defenders. She ended up saying that she wanted to represent herself because she didn't trust them. She lost faith in them. And then turned around and said, okay, well, I want public defenders back because I can't do this on my own. So they gave her back the same public defenders. And she said, no, I don't want them because I can't get along with them. I don't trust them, blah, blah, blah. So they appointed her new ones. So I wouldn't want to be this judge right now, you guys. Pryor says, I provided the prosecuting attorney staff with a 16 terabyte hard drive today. I would like the prosecuting attorney to download the entire case on that 16 terabyte hard drive. Wait a minute. Wait a minute. Wait a minute. Wait a minute. I got to go back here. I got to go back. Way back. Way back. Wait a minute. Sorry, guys. I'm scrolling way back. Hang on a second. This guy is crazy. Okay, so he says already that he has 12 terabytes of data that has been submitted as evidence. That's enough to fill a cargo van, 12 terabytes. Okay, so now he is saying that he's going to give the prosecuting attorney a 16 terabyte hard drive today, and I would like the prosecuting attorney to download the entire case on the. Are you crazy? Do you know how time consuming that would be for them to have to download the whole case, every little piece of evidence from all over the place onto this 16 terabyte? Like, he's trying to jam up the prosecution now. Madison County Prosecutor Attorney Rob Wood now addressing the court. He says, Mr. Pryor has certainly cast his fair share of dispersions on the state and law enforcement today. Calling him out. Oh my gosh, you guys. This is crazy. Okay, so when John Pryor was crying about the DNA and this and that, and he couldn't have his own expert be able to test it, which you can't have your expert test something that was consumed, which you agreed to long ago. But Judge Boyce had said that this is the way it typically works. If the state has evidence, they keep it and the defense can view it. They need to be allowed to access it, have access to it, but evidence doesn't float around. Pryor begs to differ. Judge wants the private lab DNA testing results back before he rules on this. Will issue a written ruling on the motion to dismiss indictment once those results are back. Now arguing Pryor's renewed motion to sever Chad and Lori's cases. So he's not going to make a ruling on dismissing his indictment until they get the results back from this DNA lab testing on that hair. So now Pryor is arguing the motion to sever the cases. Now this is the last motion before the pretrial hearing starts. That should be starting as soon as they're done with these motions. We will jump right into the pretrial motions. Okay, so after Rob Wood addressed the court saying Mr. Pryor has certainly cast his fair share of dispersions on the state and law enforcement today, he also says, I want to point out on the record that the defense was made aware of the electronic devices seized from Daybell's house on January 14th, 2021, more than 4 months before this case was even filed. Included with that was a document with a list of the journals. And then John Pryor says Chad Daybell has repeatedly expressed his pleasure with the job I am doing, as Chad nods his head yes. Huh. Why is he threatening to fire you then? If he has repeatedly expressed his pleasure with the job I'm doing. I gotta get that. Wait a minute. So maybe this is where he's going to jump now and say, but I'm going to fire him. Oh, let's see what he says. Oh my gosh. Like I said, you guys, if you can hear me clicking around, that's because I'm jumping from different people that are inside the courtroom to see what they are putting out. So sometimes things may be repeated, but it's because it's coming from, I've got 3 or 4 different sources open here. Hello, Georgia Driving Recovery. Talking Mama. Hey. Okay, so John Pryor is making the same arguments we've heard previously. Some evidence as it relates to Lori is prejudicial to Chad and would hinder his right to fair trial. He reiterates the DNA testing issue and discovery issues, not enough time to be properly prepared for April 3rd. This guy. So Fremont County Prosecuting Attorney Lindsay Blake is now going to address Pryor's motion to sever the cases. It boils down to the discovery issues. Mr. Pryor is now saying there's too much discovery for him to get through before trial. The prosecution is saying defense could have called the lab and went and viewed that evidence at any time, but they chose not to. So they're blowing it out of the water. He's not going to get a severance. Blake says the defense at any point could have called the state lab. There was no restriction on the defense contacting the state lab. There was no restriction on the defense reviewing what's at the state lab. They could have done this at any time in the past 2 years, and they chose not to. So you guys, I'm just checking all these different. And they're saying again that it boils down to the discovery issues that Mr. Pryor is trying to bring up, that John Pryor is trying to bring up. But what he's trying to use as a reason to sever these trials is he's exaggerating it. It's not what he's trying to make it seem. Thank you, Hockey Mama, for your comment. Well, one good thing, we didn't get hit as hard with the snowstorm and ice storm that we were supposed to. I know other parts of Ontario, Canada here, I know they got hit pretty hard and are without power, but we didn't get hit as hard as we were supposed to. Usually when we have a long break like this in between information is because they've got a sidebar or something going on. Somebody's complaining about something, and it's probably prior. And it's odd because throughout this whole thing so far this morning, I know a lot of it has been Chad Daybell's motions, but there's been a lot of stuff that was brought up. Archibald did get up and say a few things there, saying that he's ready to go, which I think says a lot. Yeah, there's still nothing else coming out yet, you guys. I'm anxious. I just want them to get to the pretrial information that's going to be coming out, because they're having a pretrial hearing this morning. So I do believe that there's probably a sidebar that's happening or something here. Something doing hush, hush, hush. So nobody can report on it. And you see that a lot where the lawyers go up to the judge's little podium there and be really quiet, especially when they don't, if there's news outlets in the room, they don't like the news outlets being able to hear that kind of stuff. So whatever's happening, it's being held back from us right now, but we're going to continue. And like I said, once this motion is decided on with the judge, if he does make a decision right now on this, great, because then we move right into the pretrial motions that are happening this morning. So we got a pretrial hearing going on this morning too, you guys, and well, it's going to be it's afternoon now. That's what I've been waiting for. So they could have taken a little break too, you guys. Yeah, and I do believe you guys, like, I think John Pryor's been in over his head on this for a long time. He should have asked for help 2 years ago and didn't. Now, that's not on the prosecution. That's on him. Hello, Lynn. England. You're in England. Well, welcome. Well, we've got it bad here, and it's just starting up the snow again, you guys. So we didn't get it as bad as we were supposed to, but now it's really snowing like crazy outside again. We've got tons of snow out there, so. Just give me a sec, you guys. Up on the top. Sorry about that, you guys. I just had somebody come in and ask me for something, so. Smiling is contagious. I'll let Chad fire him. Pryor believes in Chad, in my opinion. I'm not sure Chad could afford a decent attorney. But yeah. What kind of things happen at a pretrial? A pretrial hearing is where if there's any arguments about evidence coming in, they talk about how much time things are going to take. If there's anything that one of the defense or the prosecution, for that matter, for anybody involved in this case, If they decide that there's some evidence that they don't want in or shouldn't be brought in, they discuss all stuff like that. There's a whole bunch of stuff like that. That's getting ready for the trial. There still will be, even after this, there will be a pretrial conference. I believe that's being held on the 27th of February. So next week there'll be a pretrial conference. This is going to be the pretrial. They're just getting everything ironed out as to what's going to be allowed in, what's not going to be allowed in. If there's any arguments on other things, those are all going to be ironed out, and setting like time, how long they think things are going to take and stuff like that. A whole bunch of things happen at the pretrial hearings. Okay. Okay, so the prosecution is saying that anything the state plans to introduce has been provided to the defense, including evidence from the Tammy Daybell's phone. Oh, we've been hearing motions so far, Heather. The pretrial hearing is about to start as soon as they deal with this last motion that they're dealing with now. And then we're going to get underway for the pretrial hearing. You're very welcome, Silver Sky River Blue. So right now, the prosecution is letting them know that anything that the state plans to introduce has been provided to the defense, both teams, including evidence from Tammy Daybell's phone. So maybe there had been something outstanding there that has been recently given. I don't know. A lot of this, you guys, it has been under seal. So, okay, so Blake is saying, this is the prosecutor, Pryor absolutely had the ability to come and look at the evidence. We've repeatedly said for years now, he's known about the existence of the journals, the existence of the devices, and what we pulled off of them. For whatever strategic reasons, he's chosen not to come and look at it. Pryor references the 12 terabyte of data that the state recently turned over to him. Blake says anything the state plans to use from the 12 terabytes of information was turned over to Pryor previously. So 12 terabytes in total has been turned over. That doesn't mean that he just received 12 terabytes. Like he's trying to project and he's trying to get the court to think that I was just handed 12 terabytes. No, that was over the last few years. So he's got 12 terabytes in total. Blake says prosecutors have been going through everything ahead of trial to make sure it's all been turned over. We recognize the state has discovered things that ended up not being disclosed, and we promptly disclosed and turned that over. Blake says there have been repeated attempts by Pryor during this hearing to exaggerate the amount of discovery. See, that's what I said. And the lack of time in which it was disclosed. And that's what I said like an hour ago. He's over-exaggerating. He's trying to make the judge believe that this was all just turned over now when it has been turned over for some time. And they've repeatedly told him, this stuff, we have it. Come see it. Come examine it. And he's chosen not to. That's not on the prosecution. That's on the defense. So how do you like them apples, Chad? Are you still liking John Pryor now? You're very welcome, Heather. So now what John Pryor is trying to do is say, okay, well, we're going to hand you a 16 terabyte hard drive, and we want you to put your whole case on that hard drive. Why? Okay, let's think about this rationally. You're already complaining that you got 1,188 pages that you can't go through before trial. But now you want 16 terabytes of information before the trial. If it's the case that you didn't have this information prior, how would you be able to get through 16 terabytes if you can't even get through 1,100 pages, which are mostly blank? And I explained that, like sometimes when you print something out, if what you wanted to print out comes out on one page, but 4 blank pages come out behind it. So there was a lot of blank pages in that 1,188 pages he's talking about. And most of them were stupid ass tips that were right off the wall. So it's like, if you can't go through that, how do you expect to go through 16 terabytes before trial? Like he's grasping at straws and throwing things at the wall to see what's going to stick now, because he's really confusing himself now, or he's trying to confuse the court. I need a coffee, you guys. DoorDash, order me a coffee. So it's, I find it a jab there. I find it a jab. The prosecution came out with a little jab. We even turned over evidence from Tammy Daybell's phone. Oh, that was a jab. That was a jab. Prosecution just got jabbed out here by them, calling, basically what Pryor was doing was calling everybody else incompetent. So Wood's throwing his own jab back. We have the evidence from Tammy's phone. Asshole. He didn't say asshole. I added that. Oh, God, you guys. And don't think that I'm laughing at any of this, because this is a very serious case. There's kids and everything involved in this that have been their lives taken. It's just working in the legal field for over 30 years. I see right through a lot of stuff that the defense is trying to do here, because we've done it ourselves when we've been defending our clients. So but there's a fine line, especially with defense attorneys and prosecutors, especially when you work with them often on cases. You don't want to have a hostile relationship with any of the prosecutors, because things that they may agree to that they really shouldn't, but they will because you're working good with them, ain't going to happen no more. Yeah, so the clients that you get after this case is done and over are going to be sent up the river because of your actions towards the prosecutors in this case. If you think that they're going to want to ever work copacetic with you in the future after making comments like that they're incompetent, you just sent all your future clients up the river. So it's like, and I know the laws are a lot different between, because I'm in Canada, you guys, this is all the states, but you got to realize that all our laws in the beginning, the US and Canada, are all derived from the BNA Act, the British North American Act. Now, the US has really evolved in, getting all their laws up to date and everything else. But the fundamental and the basis of our legal systems both come from the British North American Act. Canada hasn't evolved as much as the States, believe that. I wish Canada would take a lot more of what the States have done and evolved and apply it here, but it's not so. And there's a lot of things here that we do that the States don't do, especially in the family law sector of the law. And even in the criminal aspects. Life here in Canada isn't life. Whereas in the US, life is life. So, I mean, I do wish that Canada would get up to speed with, updating their laws and setting new precedents on a lot of these older cases that are often referred to when making decisions in other cases. Until there's a new precedent set, you got to go by what the last precedent set was. And you got to, and in order to change that, you got to have significant amount of changes in evidence and stuff like that to be able to change certain things that are already set in stone and are related, and you relate and you use those prior outcomes for future cases until it's changed. And I don't think Canada's evolved as much as the US has, and I wish they would. Anyway, we're not in class here, so let me get back to this. The state has made accommodations anytime defense is asked to review discovery. We've absolutely made it available. The state is arguing Pryor is still filing a motion to sever only as a tactic to get a continuance, but they don't believe he meets the necessary burden to sever the cases. It says, same here in England. Oh, thank you. I try my best, Sky River. Like I said, am I wrong sometimes? Yes, because our laws differ. A lot of ways they're the same, but there's a lot of ways that they differ. And when they differ, it's major differences. It's not just something little. So, but I would say 80%, 75 to 80% of our laws are basically the same. But the rest of it, if they're different, they're really different. So I try my best to keep up to speed. And if I don't know something, or if I don't think that the same would apply in the US, or if somebody does bring to my attention that that's not the way it is in the US, I do look into it and I try to educate myself. It's a constant. That's almost 60 years old. I'm still educating myself. And I've always lived by try and learn something new every day. I don't care how old you are. Try and learn at least something new every day. So thank you for that, Sky River Blue. I appreciate it. Smiling is contagious. Well, do you really think Chad would fire Pryor? Is this just Pryor throwing a temper tantrum? I don't know at this point. Would he? To get his continuance and get this severed? Maybe. I don't know. This guy's off the wall. I could never get into his head to think, because what's inside this guy's head is scary. Anything's possible, my dear. Anything. I do have updates for the BK case. I will be doing a live on that. Like I said, I'm inundated here, you guys, with all kinds of stuff happening. A lot of these cases are coming up that are going to be going to trial very, 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 very shortly. And trying to keep up on the reads, and I've got private reads to do. I think I'm still maybe the end of December, beginning of January, still trying to catch up on those reads that were asked for way back then. And I do have a home life. So this year, usually in the winter, I don't really get sick other than a common cold or something like that. But there's been twice so far this year that I got really, really sick. So that set me back. But I am trying to get as much as I can. Like I said, I've got documents that were just filed in this case here that I want to bring to you guys. And there's new stuff that come out. There's two separate cases going on with the Brian Kohlberg case, if you guys didn't know. There's two separate big cases, and there's one that he wants to now be admitted as a party to. So I've got that information that I want to bring out to you guys too. He's trying to get joined into another case that's open right now regarding this whole Idaho thing. So I am doing my best, you guys. There's just a lot. And I'm one person. I don't have a team of people. If you see my little office, it's in the corner of the front of my house. I've got my living room off to the right. I mean, I got a fairly big house, but the front part of my house is basically taken up by my office here. I've got 3 monitors. I got an iPad. I got a laptop going. I'm constantly trying to keep up to date on everything. But there's only so much I can do as one person. My daughter just had a baby, so even with the emails, I'm having to answer them myself now, where she used to do that and set up appointments for reads. And that's why I'm falling a little bit more behind in the private reads also, because she just doesn't have as much time as she did have before the baby was born. So please have some patience. I'm doing the best that I can, and I appreciate you guys. So, okay, let's see if anything else has come out here. Okay, so the last that we heard was the state saying that Pryor is filing a motion to sever only as a tactic to get a continuance. John Pryor fires back. It's absolutely comical that the state is turning everything on the defense. Well, it's funny that you're turning everything on to the prosecution when it's not their fault, John Pryor. It's you. It's not the prosecution's fault that you don't have enough staff at your office to go through the mounds of evidence. You knew how big this case was. You took it knowing how big this case was. You didn't prepare yourself or your office to be able to deal with the amount of discovery and paperwork and terabytes and evidence that's going to come through your office. So you're throwing it back onto the state. The state's provided you with everything, and as they found new stuff, they've provided that over to you. It's not their fault that you don't have the manpower to go through it all. So tit for tat. There you go. Thank you, Lynn. I think it's comical that John Pryor is trying to project that he's an innocent party here. He's not. And trying to throw everything onto the prosecution when it's not the prosecution. A lot of this is Lori's fault, because a lot of this couldn't be dealt with until just this past December because of her incompetence. Blake says the defendant has waited until the eve of trial to raise this issue. We didn't see motions to compel until recently. The defendant did not request to come and look at the 12 terabytes of information he's known about for 2 years. Thank you. Thank you, you guys. Thank you so much. I appreciate you guys. Thank you. A life imprisonment in England is on 15 years. Wow. Hey, welcome back, Marie. Thank you. And we did see that. Like, John Pryor was really kind of quiet in a lot of things, especially when Mark Means was throwing out all these motions, trying to bury the prosecution in paperwork. Pryor really only spoke up a handful of times during that time. And even since then, the filing of motions and stuff like that has been minimal until a month leading up to trial. Then he's starting to come on hard and starting to bury them in motions. When you should be focusing on getting ready for your trial, you're more focused on burying the prosecution and accusing the prosecution of things that shouldn't be accused of. Okay, so Pryor again says he finds it comical the state's turning it on to him, and he says he previously filed motions to continue because he didn't have all the discovery and not enough time to go through it. The judge denied it because of Lori's case and her speedy trial rights. So Pryor claims a remedy now to get Chad a fair trial, adequate defenses to sever the cases. I don't know if the judge is going to rule on this. I just want them to get to the pre-trial motions. Let's go. The prosecutors are reiterating again that they have made all kinds of accommodations anytime the defense needed to see or review any discovery, and they've absolutely made it all available to them. So that's the stuff that cannot leave their custody for whatever reason, like the actual laptops, the actual phones, the actual pieces of evidence. They were able to go and look at that evidence, take pictures, photographs, notes, whatever they needed to do, recordings, whatever. And from what the prosecution is saying here is that John Pryor didn't do that. He did it on very limited occasions, and that he waited until the eve of the trial to raise the issues and start filing these motions to compel. And that he has never made a request to come and look at the 12 terabytes of information that he's known that the prosecution has had for over 2 years. So he's had 2 years to go over all that stuff, and he's never made a request to go and see it. Like, was he sitting there expecting like the Heavenly Father to put a floating monitor in front of him and to see all the stuff that they have over there without having to get up off his butt to go there and check out the evidence that they have over there? That's up to you to do, John Pryor. You didn't do it. You can't blame the prosecution for that. They made it available anytime you wanted to see it. It was there for you to see. You chose not to go. That's on you. And John Pryor says, nobody wants this over more than Mr. Daybell. Chad nods yes. Nobody wants this over more than me. I want to get to the trial in this case. Good. You got a trial date, Pryor. April 3rd. Get at her. For wanting this trial to go over and go through, he's making it really hard. He wants it to go over and go through and get going, but he wants it severed. And if he doesn't get that, then they're going to prolong it. Just give me 1 second, you guys. Sorry about that, you guys. I had somebody at my door again. I'm also waiting to hear from my sister. I got that on my mind too, you guys. So, heavenly floating monitor, you crack me up. Okay, let's go back here. See. Prior says they've taken hair samples from Mr. Daybell. They've taken hair samples from Ms. Vallow. He calls her Ms. Vallow again. And I'm not going to mention the number of other people they've taken hair samples from. So they probably took these new hair samples because of the new hair samples they found. So they've taken it from Chad, Lori, and several others. He wants to test the hairs to know whose they are, not just a DNA profile. Wants his own assessment with own expert made no matter the results. Just give me a second, you guys. All right. Okay, let's see what else I got here. Don't mind me here, you guys, if I got to mute myself a couple times because I got things going on in the background here in my house. Okay, so Boyce does not rule on the motions, says he will issue written orders, so he's taking them on advisement. So there's no ruling on the motion to sever or the motion to compel. That will come at a later time. Okay, let's get with the pretrial now. Let's go. Okay, so Boyce says, since motions were argued somewhat concurrently, still wants DNA testing results back first. That's why he's waiting to issue a written ruling. And by the looks of this, they're now going to close the hearing. They're closing the pretrial hearing. So during the break between sessions, Chad and Lori smiled at each other and appeared to say a few words, not sure what. So they're mouthing words to each other. It's saying that this part of the hearing is now adjourned and they're closing the hearing for the pretrial motions. So I guess that's the end today. They're sealing us out again, you guys. They're not going to allow us to get any information from this pretrial hearing. So I don't know about this pretrial conference on February 27th, if we're going to be able to see that. Are they going to close that? Right now it's open to the public. Sorry. Right now it's open to the public. But it looks like they are closing the pretrial motions hearing today. So that is going to wrap it up for us today. We are not going to be able to see or hear or anything regarding that. No reporters are allowed in the room either. That sucks. I'm hoping, you guys, that the media wins their battle on this, because I think that the public is being held back from hearing stuff like this when we're entitled to hear it. So much in this case is under seal, but little bits come out. So with that being said, you guys, we're going to wrap it up. I'm going to let you guys get back to what you were doing today. I do have a lot of information that's come out in the Coburg case. I may do that either. Well, it's going on. It's 1:30 in the afternoon here. I don't know if I'll do that later this afternoon. If not, I'll do it tomorrow. With all this stuff that's coming out regarding the Idaho 4 case and Brian Coburg case. Brian Coburg is trying to get he's trying to get listed as a respondent in the case that the media has against the state. So he's trying to be added as a respondent in that case. Interesting, right? He wants to be able to present evidence at that, and he wants to have his say at that in that case. The media has started a case in the Superior Court against, the media has started a case against the state, against the court, saying that they are being gagged and withheld from being able to report on stuff, and they want cameras and so on and so forth. And like I said, Brian Coburg has made a motion to be added as a respondent in that case. So interesting stuff, you guys. Like I said, if I don't get to that this afternoon, I will get to that a little later on, either tomorrow or early next week, depending on where I can fit it in. So this will be going private for a bit once it ends, but it will be up again within about 15, usually it takes about 15 minutes for everything to upload from StreamYards to YouTube. So do know that this will be made public again in about 15 to 20 minutes. Till the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.